Good afternoon, everyone, and welcome to the Lubar Center and Eckstein Hall. My name is Joseph Kearney, and it is a great privilege for me as Dean of Marquette University Law School to introduce this year's Boden Lecture. I do like to recall the individual in whose memory this lecture stands, the late Robert F. Boden, a Marquette lawyer from our class of 1952, a practitioner in Milwaukee, a Marquette law professor, and for close to 2 decades, the dean of this law school. Dean Boden was an exemplar to many during his career and lifetime. This was true for our students and his faculty colleagues. It was also the case for the profession more generally, especially in Wisconsin. So it seemed right, a decade or so after his death in 1984, that Marquette University Law School should create an annual lecture as one of the ways that we remember Dean Boden. It enables his legacy to continue and all of us to benefit from it. Our tradition for this occasion, now going back more than a quarter century, is to invite a distinguished academic, someone not otherwise likely to be here in Milwaukee, and from whom we can learn. There is so much that we can learn from Reuven Avi-Yonah. He is a longtime faculty member at the University of Michigan, where he serves as the Erwin I. Cohn Professor of Law and director of the school's LLM in International Tax program. I could specifically name various of his articles and books published by such presses as Elgar, Cambridge, and Oxford, but let me instead put the point more simply and directly. There is no more widely cited or better respected scholar of tax law in, certainly, the United States, or likely the world. Professor Avi-Yonah received a BA, summa cum laude, from the Hebrew University of Jerusalem, and a PhD in history from Harvard University, where he thereafter earned his JD, magna cum laude. Professor Avi-Yonah is here not to talk to us about medieval history, much as we might have welcomed that, but something rather more modern and pressing. For the title of his lecture, he has selected, "Can Tax Policy Help Us Control Artificial Intelligence?" Won't you please join me in welcoming to Milwaukee and Marquette University Law School our Boden lecturer, Professor Reuven Avi-Yonah.
I think he said he will turn on the mic. It's on. It's on. Okay, good. Can you hear me? Good. Well, thank you very much, Dean Kearney, and thank you to everybody who has been so welcoming to me here. It's really been a great pleasure. I luckily was able to come early yesterday, so I got an amazing tour of this beautiful city of yours and the law school this morning, and I really I told my wife we have to come back here because it's really such a gorgeous place. Also, it was nice of Dean Kearney to arrange such a couple of beautiful days. I'm aware that that's not always the case. Dean Kearney and I go back a long time. We were classmates at Harvard Law School together. And so we've known each other now for 35 years. Next month, I believe, is our 35th reunion. And so it's a real pleasure to see him again and to be welcomed here by all of you. And thanks for everybody who made this possible, Christine and everybody else. So as was mentioned, the topic is whether we can use tax as a tool to regulate or control artificial intelligence. This is obviously something that is now very much in the news. I mean, there's no day that passes without some headline having to do with AI. But before I get to AI, I want to talk a little bit about the way I view tax law in general. And on the first day of introductory tax, I bring the Physical Internal Revenue Code into class, which is 2 volumes and about 5,000 pages. And I tell my students that tax really has 3 functions. The first and most obvious one, the one that is most generally understood is to raise revenue for the government. I mean, no government can ever survive without revenue, and that is a necessity. Of course, there's sharp disagreement, which plays itself out in every election season about how much revenue exactly is needed and how big the government should be, but but I think nobody disagrees with the idea that some revenue is needed to fulfill essential governmental function. And the second one, which is more controversial, but still reasonably widely accepted, is that tax is probably the best tool that we have to fight against inequality of resources, to essentially distribute from the rich to the poor. And that, too, is a more or less accepted goal of taxation in especially richer countries. So those two are widely known, and then I tell the students, well, if that was all there was to it, this Internal Revenue Code would have to be maybe 150 pages long, something like that. That's the part that is really essential for these functions. It's basically the definition of what are we taxing, income, what the rates are, and the various other definitions and things that are necessary for that. So what's all the rest of it? Why the 5,000 pages? This is about the third function of taxation. In this country and in other countries as well, we like to use taxation to regulate activities. That is, to incentivize people to behave in certain ways and to incentivize them not to behave in other ways. We're all familiar with things like the gas tax, that is the excise tax that we pay on gasoline, and most gas stations like to label this much is what we charge you and this much goes to the government. When you buy cigarettes, you have to pay a tax in order to discourage people from smoking. And there are many, many other types of taxes like that. And in many situations, it is pretty widely considered that tax is a more efficient way of achieving social goals than what is called command and control regulation. I mean, a classic example would be taxes on alcohol. We used to have prohibition in this country. That is a ban on drinking alcohol. That didn't work out so well, so the Constitution had to be amended once and then amended again. We've never had anything like that in our history. And it was realized that there are better ways of doing it, so alcohol tends to be relatively heavily taxed. So those are all regular taxes, but maybe beyond that, if you just look at the income tax, and you listen, for example, to some of the proposals of the presidential candidates in this election or any election, a lot of it has to do to try to incentivize various activities. We have a plethora of proposals for various tax credits for things that the government might want you to do. And that's basically how the code grows and grows and grows in every Congress. So what I'm talking about here is the regulatory role of taxation, and specifically in the context of AI. Now, the idea of taxing AI, and I'll define more what I mean in a moment, is not particularly new. This has been around for a while. There have been two major proposals that have been around for, I would say, 15 years or more about using taxation in relationship to AI. The first one is the idea of taxing data. Modern AI is built on data. This really became a common proposal before AI became what it is now, because the concern was more primarily about protecting personal privacy, and the idea was that a company like Google, for example, or Meta or Amazon or anybody else who essentially uses your data to sell advertising, and that's how they make their money, there should be some tax on the use of the data, and so there are proposals like that. And another set of proposals was so-called robot taxes originally. The concern was that robots are, which is a form of AI, are displacing human workers, and that we should be taxing that. Both of those proposals, as I said, have been around for a long time. They are not exactly regulatory in nature. The robot tax in particular was primarily about raising revenue. I mean, the idea was we're going to get less tax revenue from humans because there will be fewer workers, and we also are going to have to spend more revenue on helping the humans that are being displaced by the robots, so let's tax the robots and then transfer the revenue to the humans. So that's a different kind of tax. That's primarily a revenue-driven tax. And the data tax, to some extent, is more relevant to regulation because certainly there are certain functions of AI that depends on how much data is used, but not all of them, and I'll get back to that in a moment. So first of all, let me define kind of what is the target of tax of the AI tax as I perceive it, and this is what I call autonomous AI. So what is autonomous AI? Well, AI in general is a machine that is capable of performing tasks commonly associated with human intelligence, except that it has much bigger memory and much faster speed, right? In some ways it is obviously better in particular tasks. So that's AI in general, but that's not what I think about when I think about autonomous AI. What characterizes autonomous AI are two things. First of all, it's the ability to learn from its own experience. That is, as it works on a problem, it gets better and better. A famous example is the AI program that learned within a day, I think, to defeat the world champion of the game of Go, which is much more complicated than chess. And so that's, those are the characteristic of the famous LLMs, the large language models like ChatGPT and the like, which have the capacity to learn from what they are doing. And the third one, and this is related, is the fact that these types of AI programs that have the capacity to learn from their own experience cannot entirely be controlled by their programmers. Because obviously, if they could be, they wouldn't have, for example, what is called hallucinations, that is, mistakes that the AI program make, because that's not the intent of the programmers, to have the ChatGPT, let's say, spit out wrong information. There's a famous story of the lawyer who just copied and pasted sites that were created by the AI program and then discovered to his dismay that these cases were simply made up. So that was obviously not something that the programmers of ChatGPT intended. And that is because they don't fully understand what the program does internally in order to produce the results. That doesn't mean that they have no impact at all, of course. They do. But there's a difference between control and containment. This is the terminology that's usually used. Control means you can really tell the program exactly what it's going to do, and it's going to do what you tell it to do. And that is, of course, typical of most computer programs, but not of this kind of autonomous AI programs, where you cannot exactly tell it what to do, or at least it will not be successful to try to do that. You can turn it off. That you can do, but that's not helpful because then it will stop working, right? Contain, on the other hand, means that you can shape its behavior in one way or another, but it doesn't rise to the level of complete control in the sense of, telling it 100% what it's going to do. So that's my goal, and that is because this is the autonomous AI is the type of AI that is usually identified as the ones associated with various problems, and I'll talk about some examples in a moment. As I said, the proposal is to use taxation to regulate autonomous AI. But before you get there, of course, you need to define AI or autonomous AI as somehow separate from its owner, that is usually the corporation, right, that owns it, like OpenAI in the case of ChatGPT, for example, because the idea is to impose tax on the AI program separately from the corporation, because, I'll get to that in a moment, but basically you want to regulate that particular program and not other things that the same corporation does. We all use AI nowadays almost every day. The AI that tells us, how to complete our sentences and various other things like that when you type into the computer. That's AI too, but it's not autonomous in the same way as ChatGPT is. In order to do that, you need to give, that's the proposal, and again, this is not new to me because this has been around for a while, to give the AI program legal personhood. That is, to give it the right to do the things that we expect a legal person to do, like, for example, to be sue and be sued, to own property, to, at the extreme, even to be subject to criminal law and the like. And of course, the example of that is the fact that we treat corporations as legal persons, separate from, let's say, their shareholders or any human being really that is related to them. And that's the model. Now, Dean Kearney said, I'm not going to talk about medieval history, but I'm going to talk about medieval history just for a moment, because this is a paper that I did when I was with him in law school. So the question was basically, well, when did the corporation exactly become a legal person that is completely separate from its shareholders or owners? So the way these old corporations, I mean, the corporation goes back to Roman law. And the way these corporations worked back then was there was what's called membership corporations. So the classic membership corporation that is around today, for example, is the president and fellows of Harvard College. So who are the president? It's called the Harvard Corporation, and there's a reason, because that is the corporation. And the idea is it's a group of people, and whenever there's a vacancy, the other remaining ones replace themselves. Replace the vacancy. So that's how, because the purpose of creating the corporate entity was to get over the fact that we all die eventually. And the idea was, how will we create something that will survive people dying? So the idea is, when somebody dies or otherwise leaves, the other people will replace it. But the point of the paper that I wrote so many years ago was that, in fact, if you read the text, the Romans did not quite get to the idea of full legal personality that is separate, because they couldn't really imagine the corporations as separate from its members. It still was treated as essentially a group of the members. And the decisive point when the change happened was in the 14th century, because the universities, the medieval universities, were corporations, and the Latin word universitas means corporation. And there were corporations of the faculty. That is, the faculty as a group were the corporation. And then, this was during the revival of Roman law in the Middle Ages, somebody asked the question, what happened if we all die? What will happen to our beloved corporation/university? And the context was the Black Death of 1748, where it was very easily imaginable that the entire faculty of the University of Bologna, where this question was asked, would die at once. And they were determined not to have the answer be, well, in that case, let's say, all the privileges revert to the Pope or to the Emperor or somebody else who will just appoint our replacements. No, they wanted independence. They wanted to ensure that there will be a continuation of their work, even if they all die at once. So that's when they decided the corporation is a completely separate legal person from all of its members, and that's how it's going to be. And this is the point where the corporation became a completely separate personality. The point of this story is that giving legal personality to the corporation serves a utilitarian goal of human beings. In this case, ensuring the continuation of something like Marquette University, for example, forever. And it's similar with AI. I mean, the reason to give AI legal personality, at least for tax purposes, but also maybe for other purposes, is precisely in order to serve the ends of human being, in this case, the wish to control or regulate AI. Now, the point here is that what I would like to do is to be able to regulate the AI separate from the corporation that owns it. It's pretty obvious that you can impose tax on, let's say, OpenAI, or you can impose tax on Google, or you can impose tax on Microsoft. In fact, we do. That's why we have the corporate tax. In my view, the corporate tax is primarily a regulatory vehicle, rather than primarily a vehicle for raising revenue or even a vehicle for the redistribution. But the problem is that if you do that, if you only tax the owning corporation, it may well be, and it is likely that in most cases, this corporation will be doing lots of other things. In fact, that is definitely true for Google and Microsoft and most of them. At the moment, it's still not true for OpenAI, but Microsoft owns a big chunk of OpenAI, and that will presumably develop. It's a rare situation where the only thing that happens in a large corporation is an autonomous AI program, or a particular autonomous AI program. And that's why I want to segregate out the autonomous AI from the corporation. Because what I'd like to do is to have a targeted tax that only taxes the AI program and not the corporation per se, because the corporation has lots of other things. And we have the corporate tax raise revenue, for example, and an ideal regulatory tax raises zero revenue. If you are able to eliminate the targeted behavior completely that you don't like, there will be no revenue at all, because there will be, the target is the behavior, and the behavior doesn't exist anymore. So that's why it is essential for the proposal to have the autonomous AI separate from the. There are other reasons too. I'll get to those at the end. There are historical limits on the corporate tax that would not apply to such a relatively new tax instrument. Now, in order to do that, I think it's a relatively simple proposition, because what you can do is have a legal rule that says that if the autonomous AI program is not in its own separate corporate shell, then there will be full liability on the owning corporation for everything that is bad with the AI program. And I can assure you that this will lead every single AI corporation to put the autonomous AI inside the corporate shell, because the whole idea of having a corporation is that you have limited liability. I mean, this is what happened, for example, with asbestos and various other bad things that were put in corporate shells precisely for that reason. So I think that is plausible. Now, once you do that, I think that you can then start taxing the program. And the tax, again, is not on the corporation, that's the shell, but it's on the program, quote, itself, as a separate autonomous legal person. Now, how would that work? Well, here I think it's useful to contrast the European approach and also some proposed approaches in the United States. So the EU just adopted essentially the first comprehensive AI law. And what it does is that it separates out various AI activities into levels of riskiness: high risk, medium risk, low risk, depending on the lawmaker's judgment about which activities are worse and which. And then it bans the high-risk ones, it regulates more heavily. The medium-risk ones, it regulates less heavily. The problem is AI is changing all the time. And so I doubt that this is the right approach. This is the command and control approach, and it assumes that the legislator knows how to classify the AI once, and then that classification essentially remains. I'm not sure that the government is in the best position to make these judgments now necessarily. I'd like to have a more flexible tool. The other alternative, the one that is more widely discussed in the United States, is that the best way of dealing with various AI harms is to use our existing legal system. And that certainly is something that makes sense. Let me give a couple of examples that are used in a recent, really brilliant articles by Ian Ayers and Jack Belkin from Yale Law School. What they say basically is they focus on two types of potential problems for AI, and there are many, many others. Those are defamatory hallucinations and copyright infringement. So if you type into ChatGPT the prompt, list the crimes that Reuven Avi-Yonah committed in the past year, you are likely to get a list of crimes. And this is, I can assure you, defamatory in the sense that I did not commit these crimes in the past year. But it is quite plausible that you will get such a list. And so what they say, well, they define AI as risky agents without intentions, and they suggest to modify defamation law so as to remove the willfulness element to it, because you can't attribute intentions to the AI program itself, and that should enable people who are defamed to sue for damages in order to prevent this kind of defamation. So that's one of the first of their examples. The other one is copyright infringement, and here we have an actual lawsuit that has already been filed because, as you may know, the New York Times has sued OpenAI specifically for using its entire, basically, back catalog of all the issues of the New York Times since the 19th century as fodder for ChatGPT. And they say this is copyright infringement. Now, I am not against this at all, nor is this my area of expertise at all, and I'm sure there are others in the room who can speak to this better, but it seems to me that this is a relatively slow tool and maybe not necessarily the most efficient way of doing it, although the two can go together for sure. I mean, the problem with the defamation example is that if every person who's defamed has to sue, that is expensive. And maybe you can get some kind of class action going, but I'm not sure, because it seems to me that the defamation is kind of specific to particular individuals, and it's a different kind of defamation every time. So I'm not sure that that's... And in the case of the copyright infringement, we have a better sense of it, because Google pretty famously was sued for copyright infringement when it digitized entire libraries of books. In fact, I think the first one that they did was the University of Michigan Library. And they were sued by the copyright owners for copyright infringement. And it took 10 years, and in 2015 they won, and they won on the ground that what they were doing was, quote, transformative. So New York Times is saying what OpenAI is doing is not transformative. And maybe they'll win and maybe they'll lose, I have no idea, but if it takes 10 years, that's a long time in AI. And besides, I don't think there's any other newspaper in the country that can afford to do it other than the New York Times. And they use, of course, endless data that is copyrighted. So here's the idea, basically. We should construct some kind of index of various harms that are caused by AI. So in some cases, this is not that difficult. I mean, you can see, if it's copyright infringement, for example, you can see which data goes into the large language model, and you can see how much of that is copyrighted, and you can give them an index score based on that. If it's defamation, I mean, you can see, leaving aside even the question whether it's defamatory, you can see how many hallucinations are produced by a particular LLM, and you can give them an index based on the level of hallucinations that they produce. You can give other examples, of course, that are worse. You can have AI producing racial bias. You can have AI producing medical malpractice, because it's used now in medical uses, et cetera, et cetera. I mean, I'm told that somebody has used AI to produce a book that is sold by Amazon called Foraging for Mushrooms, and that it can lead you to eating poisonous mushrooms, for example. Now, so the idea is basically to construct these kind of indices for various kinds of harm, and the point is that this is relatively flexible in the sense that you can change the indices over time. And then you have a tax, an income tax, and the income tax will be geared to the performance on the various indices. And of course, for various types of AI, you can have different types of potential harm because there are different kinds of programs that use the AI for different needs. And so some of them are more about defamation and hallucination. Some of them are more about this and that. So you can construct the indices differently. The model that I have in mind for this is the use of so-called ESG, environment, social, and governance indices that are ratings for various corporations, which is a pretty well-established tool out there. Of course, like anything, it can be criticized, but people actually use it pretty widely for making private investment decisions. So I think that that's a reasonably good indication that if people are willing to, put their money on this, then there's something in there. So similarly here, I think that it's a little bit like what the EU is doing, but without the need to ban certain types of AI altogether, which is essentially what they do for what they deem to be high-risk activities. So that's the fundamental of the proposal. But then there's another question, which is near and dear to my heart, because my main specialty is international tax, and that is, okay, which country is supposed to be taxing this AI? Because, of course, the world is made up of many, many taxing jurisdictions. And the problem here is, and this is one reason that I think it's essential to separate the tax on the AI from the corporate tax, that AI is different than the traditional corporate tax because it's really impossible to geographically locate where it is, or even if it is possible to geographically locate where parts of it are, it's very easily moved around. So, but in the nature of the beast, it is that the programmers can be in many, many places. The servers can be in many, many places. And essentially, the whole thing is not even related too much to the location of the programmers or the servers, because it really relates more to where the autonomous AI is itself, and it's nowhere in a way. It's, quote, in the cloud, but I mean, it's sitting on particular servers, and there's an issue as now with the energy that these servers consume, which is tremendous. But the servers can be anywhere. And so I think the only way to deal with this problem is by using the location of the users of the AI. That is, the people who are the humans who, not the programmers, but the humans who put the prompts, let's say, or use it in any other way. And that is because those are the people that we want primarily to protect. Not always. I mean, in the case of copyright, for example, we want to protect the copyright holders, but I think it's usually, that's definitely true for the corporate tax too. And one of the things that have happened in the last 10 years is that people realize that the best way of taxing the digitized economy altogether is to try to focus on the things that are less movable. And the thing that is less movable is the location of the mass of consumers. That's the idea behind the data tax. The data tax is supposed to be on where the data is located. It is where all the consumers, the users of, let's say, Google searches are located. And so the proposal would be to have these countries apply the tax based on the location of the users. And I think that's the one that is more appropriate for this particular kind of beast. So that's essentially what I'm trying to achieve. There's one thing that I'm not doing, which some of you may have heard about, because a lot of the writing about AI these days is about AI that doesn't exist yet. And that's probably a good thing, because the writing is about what's Ray Kurzweil called the singularity. That is what he calls AGI, artificial general intelligence, which basically means the point at which AI will be indistinguishable from human intelligence in the ability that we have to turn our intelligence to any use whatsoever, and not to a specific task that is assigned by the programmers. So I think it's safe to say that no AI program in existence now has quite reached a level of AGI, artificial general intelligence. They all are ANI, artificial narrow intelligence, because they are geared to specific tasks. And certainly not what he calls artificial superintelligence, which means an AI that is much smarter and better than any humans. This is why people say it's a danger to humanity to have AI. We're not there yet. I'm not in a position to judge, but what I'm trying to do is regulate the AI that exists now, and I think that tax is one way of doing it. Just to emphasize, and I will finish here so as to leave plenty of room for questions, this is definitely a work in progress, and it relates to what I know. There are many, many other aspects that I don't know. I certainly don't know nearly enough about AI itself. I mean, I've learned a lot from working on this project. But the point is that this proposal does not necessarily mean that there shouldn't be other things happening. Maybe even something like what the EU is doing, although I'm doubtful that that's the right approach. But certainly it seems plausible that we will be able at some point maybe to use the existing legal system, the tort system, the copyright system, and so on, to also regulate particular harm or the other legal system that we have in place. And this is perfectly okay. But I think that the advantage of tax, going back to where we began, there's a reason that Congress likes to use tax for all of these regulatory goals. Frequently, tax is the most efficient way of doing it. It's usually superior to command and control regulation because it relies on the private sector, and the private sector usually knows more and is able to respond better to this kind of regulation. I mean, the idea, of course, for example, would be to incentivize. I mean, in the end, it all goes back to the owners of the AI in the sense that it's their money ultimately and the money of their shareholders. And so you want to incentivize Sam Altman, who now is going to get 7% of OpenAI, I read, to work as hard as he can to prevent hallucinations in general, and defamatory hallucinations in particular. And if there's going to be a tax on that, that's an incentive. Fundamentally, there's no question that this is designed to incentivize humans, and this is the way that these kind of regulatory taxes work. Even if they apply to corporations, for example, and as I said before, I think most of the corporate tax is about incentivizing corporations. In the end, of course, it's about incentivizing the management, incentivizing the shareholders, and so on, because the AI program itself is not, just like the corporation itself, even if we give it legal personhood, it's not conscious in the way that it itself will respond to incentives. But I think to a significant extent, humans can hopefully contain it in ways that will reduce the harm that we perceive from certain uses of it. Thank you very much.
Thank you. This one is on, as was yours. It was not on a moment ago, is my point. So thank you. We have a good deal of time for questions, and the custom is for anyone to raise his or her hand, and I will recognize the person, and I may end up having to repeat the question so that all can hear. Professor Meisey is in already, and then Dean Grossman, so go ahead, please.
If I understood your proposal correctly, unlike the corporate tax regime where we give residence to corporations, you wouldn't give residence to AI. It would basically treat it in every jurisdiction as a non-resident?
Yes, that is in fact a proposal. My view for a long time, as you may know, in particular, is that corporate residence is pretty meaningless. That is that I do not believe that corporations as a legal person has a residence. I mean, there are all kinds of ways to try to define residence of corporations. I mean, the way the US does it is particularly, not meaningful because it simply defines residence of corporation based on where the corporation happens to be incorporated. So that means that the residence corporation is 100% under the control of the taxpayer who incorporates it. But even jurisdictions that try to do it a little bit more meaningfully, like the UK, where the corporation is, quote, managed and controlled from, have been failing in the face of modern technology, because it is now possible to run a corporation with the CEO in one place, the other chief executives in other places, and it doesn't really have a defined headquarters in any particular location. Or alternatively, as was evident in the case of FTX, to put everything in Bermuda, right? That is in a tax haven. That's where Sam Bankman-Fried and his friends actually lived. So I don't believe in taxing corporation based on residence at all, and it becomes even worse with AI, because at least with corporations, you can identify where they have assets, you can identify where they have employees, You can, and you can identify where they have customers. But in the case of AI, I don't think the employees are autonomous. I don't think the location of the employees is that important either. For one thing, they're likely to be in many jurisdictions at once. So where is ChatGPT resident? Who knows where all the programmers are located? The servers may be in one physical place, but that's really easy to move around. So that's definitely not resident there. So I still think that for that, even more than for the traditional corporate tax, it's the location of the users or consumers. That's the one factor that is relatively immobile, and that's the jurisdiction should tax. But yes, so this is, to use our terminology, entirely source-based taxation.
Okay, because what I like about your proposal, I think it'd be very suitable to other sorts of IT, like software, where you don't really know where it's being used,
So
where it's being coming from.
I have been for over 30 years now fighting to do exactly that, with some lack of success, because for one thing, you need to change. This is one reason that I don't want to apply the corporate tax. You have to change 3,000 plus tax treaties at once in order to achieve this goal, and that turns out to be a very, very difficult do. The OECD is at the moment trying very hard to do exactly that, except that they negotiated this immense multilateral convention, maybe 900 pages of it, and then they gave the United States Senate a veto over it. So you need 67 senators. Good luck with that, right? So basically my view is it's not going to happen.
Thank you. Go ahead, please.
Yes, so this is interesting. I'm curious how you get access to, where's the money to collect your tax from? If you're saying the collection is from the AI program, it's not really its own asset with resources. Are you still collecting from the owner or owners or developers? I'm just curious how you get access to assets to pay the tax. I'll leave it there. So I have a follow-up question. I'll see what you say, though.
No, this is, of course, a great question. I mean, the reason to give the program legal personality is that it can have assets to pay the tax. Now, of course, the issue is, how do you segregate the revenue, let's say, from ChatGPT from possible other sources of revenue that the company has? This is why I said that I'd like it to be in its own corporate shell, because I think it would create if you say that unless you segregate that revenue in, let's say, a bank account that is owned by the program, then all of your bank accounts are potentially subject to the tax. That is, you eliminate limited liability for this program. And I suspect that this will create an incentive to segregate out the revenue, because you can, I think, identify which revenue stream, quote, is earned by the program as opposed to other things. Maybe that's going to be an issue, but I do think that it's plausible that if you, again, incentivize through the use of limited liability, this is certainly, again, how corporate personhood developed. Limited liability was not existent in Roman times. It was not existent in medieval times. It wasn't even existent in the UK during the Industrial Revolution. Limited liability was an American invention, basically. And it arose through the competition of the various states to attract corporation and corporate in corporations, which produces nice fees. And so a state like Massachusetts was one of the first to announce that if you set up a corporation here, all the shareholders are going to have limited liability. And that was sufficient to create it. And I think it's the same here. If you're going to say that this AI program has its own personality and we're going to impose a tax on it, and if it doesn't have sufficient resources, we're going to pierce the corporate veil and apply to all the resources of the corporation that owns it, then I think that would create an incentive to segregate the revenue stream adequately.
Professor Lemon and then Professor Tierney, all the full and part-time faculty are all over this, and then we'll go to you. Go ahead, Alex.
I figured it would be okay to ask a question given the amount of time that we have.
Yes, please.
I'm wondering how you know what amount to impose as the tax. And the reason that I'm asking that is that it seems that unlike the example of cigarettes, we don't want AI to go away completely. We want only defamatory hallucinations to go away. But if you impose too large a tax, then that risks destroying AI completely, right?
So I think the idea would be to have a tax rate that adjusts to the harm, right? So the tax, I mean, if let's say you start the tax rate at a relatively high rate, but you tell the company the less hallucinations you produce, the more the tax rate will go down. And I think that certainly all of these companies, I'm sure, are working really hard to reduce the hallucinations. I mean, this is a problem for them. This will incentivize them to work on it even more if it will hit them in their pocket. What I would like to do is to have a flexible regime. Now, there are issues with this. For example, it is not clear that the IRS, for example, has the ability to set something like tax rates. This thing came up very much in the context of discussions about the carbon tax. It is rather widely recognized that the carbon tax is more efficient than certainly command and control regulation, but even than a cap and trade type regime in reducing greenhouse gases. But the concern was that if Congress sets the rate too high, then it will create too much cost uncertainty for the private market. And so the suggestion was made that the EPA would really have the ability to adjust the rates as it achieves the desired reductions in pollution. And people have argued that this would be unconstitutional to delegate to an agency the ability to set tax rate, which is definitely, taxation is reserved to the Congress, and there's the origination clause that says that it has to start with the House of Representatives and so on. So it's a particularly problematic area. So what I'm thinking about is something like the rate will be set by Congress, but the legislation would say that it is geared to some kind of harm index, as I mentioned, and the fewer the hallucinations. But your question exactly goes to the reason that I don't like the EU legislation, which simply bans whole categories of AI as too risky. I don't think they have the ability now in 2024 to know how various categories of AI, and what people say is that AI will simply not be developed in the EU, and maybe even not be available in the EU, which is a problem because this is clearly a massive growth field for the economy, and one in which we would like the US to retain its current predominance.
Go ahead.
This kind of looks like an excise tax on particular activities imposed by the user's jurisdiction. So you'd have to, in effect, internationally coordinate a form of tax. Is the notion to gather a fund to compensate harmed people, or are you going to attempt to tax harmful activities? I'm saying that poorly, but I think you see the point.
Yeah, no, I do. My hope is that there will not be any kind of international coordination necessary. I mean, that's the problem with the OECD thing that I mentioned before. But the reason that they negotiated this multilateral convention to begin with was because countries were beginning to do this unilaterally. And the way they did it was by adopting the so-called digital services taxes. The French were the first, and then the UK and Italy and a few other jurisdictions, including recently Canada, adopted it. The US threw a major hissy about this. They imposed tariffs on French goods, luxury goods, wines, and the like, and they threatened all the other ones. But they reached a compromise on which these taxes would be put on hold, and pending the negotiation of this massive multilateral agreement, except that now it's clear that it's not going to happen. And so on January 1, 2025, where this hold expires, I expect about 30 countries to adopt it. So the way they work is that they have a relatively low tax rate. The French rate, for example, is 3%, but it is on all provision of digital services into the economy. Now, that's, of course, too broad for me. So I would propose something like that, but only for the kind of services that I'm trying to target, with a rate being adjustable up and down, depending on your judgment of the harm to consumers or users in your particular jurisdictions, who are the one who you are trying to protect. As I said before, there's still issues, for example, that the instance of copyright is not geared to the users, it's geared to the authors, right, who may be in a different jurisdiction. And I think that that's something that may need to be resolved through the use of, through putting these revenues aside in a fund of some sort to compensate them. But certainly in the case of things that are consumer harming rather than author harming, I'm thinking about defamatory hallucinations, I'm thinking about racial bias, I'm thinking about medical malpractice, all of these things that we use the tort system now to regulate. I think it is plausible to do this in the country where the victims of the tort are located, and that you can use. I mean, the DSTs are well established. I mean, one of the ironies of the situation is that the U.S. agreed for the countries that have been collecting the DSTs, like France and the UK, to continue collecting them from, Google, Amazon, Meta, and so on, with the understanding that, and the tariffs were lifted because of this, with the understanding that if the multilateral convention ever comes into effect, then these revenues will be used to offset the taxes that are due under the convention, except that everybody knows now that that convention is not going to happen. So they just pocket the money. And one interesting thing about this is that the revenues have been significantly higher than what they anticipated. Now, here I'm not primarily about, this is why it's so popular. I'm not primarily about revenue, but I think that this shows that it can be done, and that some critiques that have been voiced, like how do you know where the users are located, turns out that it's possible to know where the users are located.
Do you have a question?
Yeah. I work on AI.
No.
And have you thought about two things? One, the easy one. Any insights from what the patent office has been thinking about and rejecting or embracing? They insist that the human element be involved.
Mm-hmm.
But the question I wonder is, you mentioned, taxing the users. Have you thought about flipping this a little bit or shifting it to, AI is simply applied against data. And with growing regulation of ownership of data, and, if this is to prevent harm, introducing somehow into your concept, is it the users? Is that the right metric, or is it something, a widget associated with the data?
So the first question is fascinating, and I just don't know anything about it. It would be very interesting, and I should look into this. So what you're saying is that the patent office has been doubtful about certain patents related to AI because of the potential harms associated with them. Well, but that's true for all patents. I always understood that patents are always in the name of a human that is then gets transferred to a corporation. That's not just unique to AI, right? Yeah, you can't submit an application in the name of a corporation, yeah, but if you're an employee of OpenAI, then OpenAI gets the patent eventually, right, after it's granted. I think the interesting question for me would be, is the IP system a good tool to segregate out the kind of AI that's likely to be harmful than the kind of AI that's likely not to be harmful? And I'm not sure, simply because, again, you go back to the issue that the humans who program the AI are not themselves sure how it works, because if they were sure, they would prevent it from doing the bad things that it does. It's not intentional on their part either, not just in terms of the AI. Now, on the other issue. So this is, I mean, what you're saying is that, if I understand you correctly, is that it's all related to the use of data, and that is to some extent true, and this is why people have been proposing the data tax. And in some cases, the data tax is definitely an appropriate tool in the sense that, for example, for copyright infringement, the more data an LLM has, the more likely it is to be infringing copyright, so a data tax makes sense. Same perhaps for privacy protection, which is a big thing, of course, in the EU legislation. But there are other instances of potential harmful use of AI where it actually works the other way. I would guess that the more data an LLM has, the less it's likely to have hallucinations. At least I hope so. And this is part of the thing that they're working on. That is, sometimes more data is good. And the problem with data taxes, as I understand all the current proposals, is that they're essentially flat. That is, they don't distinguish between bits. All data is treated the same and is subjected to the data tax, which is also feasible, and it was designed to think about data as the new oil, let's say. It's a royalty that is paid to the jurisdiction where the consumers whose data is being used by, let's say, Google, to sell advertising are located because they're entitled to protection, this kind of protection of the data. That strikes me as not a flexible enough tool, simply because you can't easily calibrate the level of the data tax to the harm that you're trying to do, which is why I'm trying to use the income tax, which is geared to profitability, to target, and that's in the end also what the companies obviously most care about is profitability. So it relates to the previous question, how much tax is too much? And there's no question that there are levels of taxation that would eliminate activities, although, Chief Justice Marshall famously said, the power to tax is the power to destroy, but there's also a nice sentence in one of Oliver Wendell Holmes' opinions from the Supreme Court, the power to tax is not the power to destroy while this court is sitting. I mean, at some point it gets to the level of a taking, and I suspect the court will have something to say about that.
So I want to leave the formal presentation there, but let me say three things. Well, no, this is great. A thank you, a please, and another thank you. Thank you to all of you for joining us this evening. I'm very grateful for faculty, students, practicing lawyers, judges, members of the community more generally. This is just a wonderful gathering. Second, please join us outside in the Zilber Forum for a reception. That's why I distinguish this as the formal part coming to a conclusion. We will give Professor Avi-Yonah a glass of water and a cookie, but he will be available for individual questions too. And as you can tell, such interest and engagement. And this brings me to my third point, which is to say a thank you, a warm thank you to Reuven Avi-Yonah. I mean, if I had known, I wouldn't have waited 22 years to devote the Boden lecture to the topic of tax policy. I thought I needed a couple of decades of credibility before I did that, and I was wrong the whole time. This was wonderful. So thank you, Professor Avi-Yonah, and see you outside.
Thank you.